All right. Hello, everyone. It's Nickolas, Wildstar candidate for governor. That was the wrong intro there. I'm working remotely from my laptop and am in the car since my son is in the bedroom, in the hotel room sleeping. I'm actually out in San Diego at this time. Excuse me, celebrating his second birthday at Legoland. Yay! So we just got through enjoying an amusement park, which thankfully did not force us to wear masks or require for us to show proof that we've been vaccinated in order to enjoy the rides. So I'm encouraging all of you out there watching to please also do the same. Just continue to live life as if it was normally before this whole pandemic panic began, because there is no greater fear than fear itself. And we need to start having faith in life and liberty and freedom, all of that good stuff, right? Speaking of which, there is a monumental case, breakthrough case, that we're going to be discussing here today on this community Q&A. So I have a quite a panel here of guests that I'm going to be including in the conversation. So let me introduce them to you now. Got my man Daryl Cotton from 151 Farms in the house. Hey, what's up, Cotton? I got Dave in the house. I also got Flowers. I don't think we met before, but I'm glad you're here as well. All right, let's talk soon. And Krista Koenig from Sloan County here as well. And Randall. Not sure we had a chance to meet it either, but I'm happy that you're here in this chat also. So thank you for being here. There was someone else. Maybe they'll jump back into the session here and I can include them. But in the meantime, I'm going to let our friend Daryl Cotton of 151 Farms take it from here and tell us what's going on.
Thanks, Nick. I hope everybody can hear me. I believe my audio's coming through okay, right?
Yes, sir.
Cool. So first of all, Nick, thank you very much for standing up and running for governor. It's not easy when you don't have a lot of money and a big campaign staff to support you. But what's remarkable about Nick is that he's taken this on as a personal challenge to restore our liberties. And that's so important. Where we are cannabis patients, medical cannabis patients, we've seen our rights taken away from us. And here we are right now looking at only two candidates right now in the re-election. It'd be Nickolas Wildstar and Jacqueline McGowan that have a cannabis-centric message as to what they want to change. Nick, can you briefly just tell us what do we have going in the next 13, 14 days before the election? What do you see happening? What do you need? And what can we do as voters to make the right decision?
Well, of course, just be informed as to who you're going to be voting for. It's a lot of people that are unfortunately casting their ballot based on celebrity appeal by some of the celebrities and rich people running for governor. So they've already casted their ballot for them. But for those that are still holding out and want to invest their vote into someone that's going to truly represent their values and what they desire for the state of California, then I urge you to please visit my website, wildstar2022.com. Right there at the bottom of the screen, find out more about my campaign platform proposals and what I'm going to be doing on over the next few weeks. I'm going to be at the Fresno Gun Show this weekend, since I'm the only candidate that will make California constitutional carry on my first day in office. So I'm attending as many gun shows as possible to get that message out there. The Fresno Gun Show this weekend, Labor Day weekend. Then September 11th weekend, I'll be in Tulare for their gun show. So if you're in either county, please be there. Monday, September 13th, I'll be holding the last call for recall Gavin Newsom protest at the state capitol. That'll be from 11 a.m. till 2 p.m. in Sacramento. And then election day is Tuesday, September 14th. So we have no time to waste right now. This week, I'll be I'm on a family vacation, but next week I'll be doing debates all week long, Tuesday, Wednesday, and Thursday. I have debates lined up. Some more interviews. I just did an interview earlier today with the LA Times. So continue to look for more information from me from major publications. hopefully they'll be able to get the few stories that they've done about me out there before election day. But if anything, like I said, people need to dig into the details, do some research on the candidates that they're going to be voting for, and cast that ballot now since you are able to vote. The final day to vote is September 14th, but everybody in California is registered to vote, have gotten a mail-in ballot already. And they will be starting in-person voting starting September 4th statewide. So some counties like LA County have already started in-person voting. So if you want to vote in person and not, through the mail, then just vote in person.
Well, let me ask you, what have you done specifically in your campaign promises that would benefit the medical cannabis patient? What have you promised to do your first day in office?
Nullify Prop 64, since it has definitely hindered the cannabis industry from being able to prosper and grow as it would be organically without, corporate control or governmental control.
Well, you've sent a letter off to our California Attorney General Bonta. Let's focus on that. Of all the candidates, has there been any candidate that's done a deep dive like you have into the substance of what happened when Prop 64 is passed and what you personally have challenged this California Attorney General with in terms of nullification of the Prop 64 law? You flat out told him what was wrong with it, right?
Absolutely. That letter that was sent to AG Bonta was mailed out back in mid-July, and I sent him another follow-up letter afterwards to again inform him of my intent to nullify Prop 64 on the grounds that it has positive conflict with federal law. So thanks to a good discovery.
None of the other candidates have done this deep of a dive, Nickolas, and that's the thing. You don't get a lot of the media attention, but you have a core group of people that have taken the time, as you have, to really understand this subject. So we have some really good news to share with you, your campaign, and all of those people that have suffered under Prop 64. Do you care to hear about it?
Absolutely.
Okay, do me a favor. Well, guys, we have a couple of things to talk about as a preface. So Prop 215 and 420, these were compassionate cannabis laws that allowed a very wide range of people to access cannabis under medical cannabis laws in California. November of 2016, everything changed with the passage of Prop 64. And what that meant is we were going to have for-profit taxable cannabis. And this patchwork quilt of laws that start in Sacramento, but allow each individual community to sort of make their own mini quasi-monopoly in terms of how they license cannabis in their community. And by doing that, what do we end up with? Corruption. So some of our guests today have had personal experiences going on 4 and 5 years. We're going to want to hear from them. But before we even get into the personal issues, the beautiful thing that's happened is positive conflict has been proven. So the purposes of tonight's podcast is to talk about a case. It's called the Iron Angel case, okay? And it's very similar when these people that own properties that are eligible to grow cannabis on are approached by other people who promise them these great profits and everything will be handled, the permits and so on. And most of these consultants are all full of shit. They're going to steal from you. They're not going to deliver. And at the end of the day, you're going to be left with less than you came to the table with. This is just what we're across the state. And it's forced us to take a hard look at 64 and what we really voted for. Not that it even passed by that much. It only had a 57% pass rate, which, considering who was behind it, you had Soros and Sean Parker, big money. And we had Dennis Perone and those of us that, rely on cannabis for the medical benefits. Thank Dave. He had one of the biggest collectives in California. He's here. So as we all came together to help Nick understand, what he can do for the campaign to run for governor, and when elected, immediately repeal or nullify 64 and bring in something that returns us to common sense, compassionate medical cannabis. And we've done that in something called the Restoration Act. But with no further ado, I would like to tell everybody there's 2 major Facebook groups. One's called the California City and Regulation Watch, or CCRW for short. And that particular Facebook group is 8,800 strong. and it's ran by his competitor. Her name is Jacqueline McGowan. And Jacqueline has running for governor as a Democrat, suggested that we vote not to replace Newsom, but if we're going to replace Newsom, vote for Jacqueline. And she's well-financed. She's a blonde female, California look and all that. And she does understand cannabis law and regulation. So she's attracted a lot of people to try to maintain Prop 64. And we are absolutely against that because you cannot maintain an illegal law. We, on the other hand, have a banned members CCRW group. And we created that for everybody that's been kicked out of Jacqueline's group. We now have what's called the Very Public CCRW group. I would urge everybody to go to that. And before we actually break here, Nick, and go to Very Public, which is where we're going to find all the documents that we're going to be addressing tonight, I just want people to know, when you're a public figure and you start banning people from your Facebook group, you are violating a number of civil rights issues, the First Amendment being one. In Nick's case, he was on there, he was banned, and you weren't given a reason. You were just shut out. Joe, the list goes on. Dave, me. So we're not given that.
And I was a member before she declared.
Exactly. But 8,800 members for cannabis who all want to talk about this thing, and our opposing viewpoints are not allowed to be aired there. And it's tyrannical control that she maintains over that. So that gives us something that we're talking to lawyers about in terms of action against the state for having passed Prop 64, saying there's no positive conflict with federal law. What we're about to show you tonight, there is, and the federal courts believe that and have ruled on it quite recently. So with that being said, and the fact that we need one other co-defendant, and that will be Jacqueline McGowan, your competitor, I would like to introduce everybody to the Very Public Facebook group. Can you bring that up for us?
Yes, sir. Give me just a second. Okay, so this is going to look weird because it's going to do like this tunnel thing, but I'm going to bring it up.
All right.
All right.
So,
you see it?
You see the post? You see the post where there's section 11 that's described as no positive conflict?
Can you guys see the screen share?
Is it hard to read?
It's hard to read. I can see it.
You can?
I can see it. It's hard to read for me, but I'm blind.
Okay.
No problem. I can read it off. Where am I going to get? Oh, here it is.
Just Nick, I read it earlier myself, but you can provide that for others.
Yeah, I need a nice loud reading of section 11 and what AMA. This is actually language in AMA that states what by passing Prop 64 or AMA, you will have this particular protection. Go ahead, Nick. Read that aloud.
All right. Section 11, construction and interpretation. The provisions of this act shall be liberally construed to effectuate the purposes and intent of the Control, Regulate, and Tax the Adult Use of Marijuana Act, provided, however, no provision or provisions of this act shall be interpreted or construed in a matter to create a positive conflict with federal law, including the Federal Controlled Substances Act.
Stop. What did they just say?
They said that it can't be interpreted in a manner to create a positive conflict with federal law, including the Controlled Substances Act.
The Federal Controlled Substance Act, the CSA. There it is. All right, keep going. Sorry.
No problem. Such that the provision or provisions of this act in federal law cannot consistently stand together.
Okay, guys. So let's start with that concept that as voters, we were determined to understand that, hey, our government, state government, has gone ahead and maintained that by passing this, we would be in compliance. There'd be no positive conflict with federal law. Well, here we are, 4.5 years later, and along comes Iron Angel. You know what we might do, Nick, is pull this up off the 151 website. If you just go to 151farmers.org, you'll be able to go to my website, 151farmers.org. Yeah, and then pull up 11.46 under Canagreed. So this is where I've housed everything related to my case, the activities we see in Mendocino, Humboldt, SLO, Santa Barbara now, San Diego. So it's a systemic problem up and down the state, folks. And I've really never wanted to get into this, but now that I'm into it, frankly, it's something we got to do something about. So
Yeah.
we've been given a gift with Nick and this case. So the class action.
You got a duty to take action.
If you go to Canagreed, Nick, stay awake, stay aware of my story. And this is a huge online presence, but just drop all the way down to 11.46, and that'll give us the Iron Angel case.
All right.
All right, so it's 11.46. You got a ways to go, bud.
Yeah, I'm scrolling.
Yeah. So the first thing we're going to do is open up the actual complaint, and we're going to describe what's in a federal complaint when two parties are suing each other over cannabis law.
Wait, you said 11.46?
11.46. You got a long way to go.
I got 11.65.
No, that's .65. So you're at 11.46. You got a long way to go. There you go. Keep going. So what ended up happening is her name's Francine Schulman, and she had somebody come to her and suggest that he could run her farm and everything would be hunky-dory. She's got the experience. He's a master grower, so on and so forth. So if you look on here, so what I've done is I've dated him, so it's chronological, and then there's an ECF number. You'll notice, but while we're looking at this, ECF1, that's the original complaint. But look at that next one down. That's all down to ECF 72. So there were 71 other filings that I did not include. So all that we're going to concentrate on tonight is the complaint and what happened in this decision. Go ahead and open up ECF1.
All right.
Is this a little easier for people to see? I don't know. Can people see this any better?
Are you able to see that clearly?
Okay, I can see it fine. I hope everybody else does. But just to quickly surmise this, all right, I'm only going to stay pretty much on the first and second page. Baker Botts is a very high quality, top tier law firm, okay, out of San Francisco and a Palo Alto office here too. And they're representing Francine Schulman. She's the property owner in San Luis or Santa Barbara. It's actually Lompoc. And she had a problem with a Todd Kaplan. So if you can see towards the bottom there, Todd Kaplan is like one of many people that will come in and make these grand promises of what they can do to your property. But before you know it, they're stealing your trademarks, they're stealing your life's work, they're stealing your dreams. They're charging you, money's unaccounted for. 99% of the time, they're wasting it on strippers and coke. And the next thing you know, people are dying. And I'm not kidding about any of this. We have great evidence of this in San Luis Obispo. Now you start having criminal problems. But what I'm proposing tonight is we have civil remedies that will take down the problems that Prop 64 created. And this particular case got brought into federal court for violations of RICO conspiracy, fraud, negligent representations, breach of contract, etc. Let's go down to page 2. All right, let's keep a little higher, right? Let's just see everything, the economic advantage, intentional infliction of emotional distress. She's actually got an elder abuse claim, too. In California, if you're 65 or older, you can include elder abuse. And we've seen that before, too. So all I can tell you at this point is you have one of the top-tier law firms in the United States taking a federal RICO case to trial, or, you know, to at least filing the complaint, and we're astonished when this happens. This had lots of news. Everybody was looking at it, and we wanted to see justice in our federal courts. And Section 11 said there's no positive conflict, so you would think that this is something that could be tried at a federal level. But unfortunately, there's something called the Supremacy Clause, or the doctrine of preemption, which says when federal law and state law conflict, then federal law trumps state law. Higher courts trumps lower courts. So let's go down to ECF 75. This is what happened in that case. You're going to back arrow 1. Okay, and the next one down, ECF 73. I'm having a order on motion to dismiss. I'm sorry, it's one up. Yeah. How many pages is that?
Notice of appeal. This one's 11.
Yeah, that's it. So
Page 8.
please go back to the one before. I just want to refresh my memory.
This or this document?
What's that one? Order on motion to dismiss.
Okay. The appeal one is the one that you showed me for page 8.
All right, I'm going to open this up on my particular website so I can see it. And anybody that wants to follow us right now, if you can open up 151farmers.org, go to CanAgreed. It'll be a lot easier than trying to see it on this screen. And then when you're on CanAgreed, just drop down all the way to 11.46. All right, so you're very capable to go back and see the original complaint. We just touched on that. But that order dismiss, that's on ECF 73. And I'm going to open that right here. It's one of 6 pages. And well, here's what happens. Kaplan, and it's described nicely here, provides an order to dismiss the case, saying that the federal courts do not have jurisdiction because there is a violation of the Controlled Substance Act. And when you're arguing for lost profits, that presents a conflict to the federal courts to try to rule on that. Well, right. That is, by definition, a positive conflict. Correctly interpreted, which is what we're about to see, under 12b-6, this is a federal rule, it can be dismissed. All right, so I'm going to go ahead and back out of this, and I will ask you to go to ECF 75. This is the notice of appeal, and this is where the gold is, guys. All right, I'll give you guys a second to get there. It's one of 11 pages, okay? And whoever can read this with me, I'm going to pick a paragraph, and then whoever wants to jump in, go ahead and drop down to
8.
Page 8. We're at a section 4 called discussion, okay? Nick, can you see that?
Yep. Can you guys see it?
So, Nick, read it aloud. What are we talking about in this discussion 4? It says A.
All right. So plaintiffs cannot allege violations of 18 USC 1962 C through D and 1964 C RICO because any remedy would violate federal law. Claims 1 and 2.
Okay, so what they're specifically supporting there is their motion to dismiss the case. The federal judge is saying, no, you cannot be heard here because this would violate RICO and lost profits and criminal activities would violate federal law because your state law is your state law, but it doesn't rise to the level that we can adjudicate it. So basically what he's going to do is send this back down to state court.
And just so people know, filing a RICO lawsuit is extremely difficult. I think off the information that I read, there's about 900 RICO cases that are submitted each and every year, and about 85% of those get rejected.
Yeah, that's very true. So I'm going to read the next paragraph. Maybe Dave or Krista can get the following. Defendants argue, that would be Kaplan, that plaintiffs, that would be Ms. Schulman, do not have a legally cognizable interest in their RICO claims because the alleged damages relate to a cannabis business, which is illegal under the Federal Controlled Substance Act. Now, I recall Nick reading a minute ago that there would be no positive conflict with the CSA, Nick. Didn't you just read that? Okay, so here it's saying that's not the case. And that's in 21 U.S.C. Section 801 et sec. CSA. We're going to start referring to it as CSA. Plaintiffs counter that other courts have held that just because a party is violating one federal law does not give it license to violate another. So that was Schulman's argument that, we should be here because no matter what you decide about the Controlled Substance Act, we shall still be heard under RICO. Dave, please go.
Go for it.
Plaintiffs seek damages for injury to their business, including defendant's scheme, that would be Kaplan, to take over Ms. Schulman's cannabis business. Sound familiar, Krista?
Yes.
As a result, plaintiffs lost control over their cannabis cultivation operation for a time at the it's Anchor property. They lost their opportunity to purchase and cultivate cannabis on the Wellsprings property. Plaintiffs' damages under RICO are inextricably intertwined with their cannabis cultivation. Any relief would remedy plaintiff's lost profits from the sale, production, and distribution of cannabis. Okay, fair enough. It's well defined. Anybody go ahead. As such?
I'll take
As
that.
such,
Oh, go ahead. Go ahead. No.
okay. As
Ladies.
such,
You got to muscle in here, guys.
all right, here's my fist. As such, the court finds that any potential remedy in this case would contravene federal law under the CSA.
What did they just say, Krista?
The court finds that any potential remedy in this case would contravene federal law under CSA.
Dick, there you go, brother. There's your positive
know.
conflict. Okay, Krista, sorry to interrupt. Go.
No worries. A court order requiring monetary payment to plaintiffs for the loss of profits or injury to a business that produces and markets cannabis would, in essence, 1, provide a remedy for actions that are unequivocally illegal under federal law, and 2, necessitate that a federal court contravene a federal statute, the CSA, in order to provide relief under a federal statute, RICO. The court finds this approach to be contrary to public policy.
Contrary. So that's not positive. That's contrary. And this is a wonderful paragraph, and I'll tell you why. People have asked, how did Baker Botts, a high-tier law firm like that, not know that they couldn't take this to federal court when it was a direct contravention to federal law under the Controlled Substance Act? And I've had people tell me they're guilty of malpractice for having done that, okay? I personally feel that it was wrong-headed, and here's what happened in my case, because I'm 3+ years in federal court as a pro se litigant, and I'm not an attorney, but what I did do is I backed RICO out because I realized there were civil rights violations occurring here, and if I went into federal court and I argued RICO, and I'm starting to talk about lost profits, I'm going to get the boot. So here we are, and I just came across this case 3 days ago. And what we find is by keeping RICO out of it, then you are still in federal court for the civil rights violations. Okay, does that make sense to everybody?
Mm-hmm.
That's why I'm still there 3 years later on my federal complaint. Go ahead, Dave. Hey, Dave, you with us?
Did we miss somebody?
Tracy,
Yeah, I got.
Tracy, you there? Flower, you want to take this? This is
I'm
good.
kicked off.
Okay, if nobody can read it, I'll read it. The court also notes that it seems implausible that RICO, a federal statute, was designed to provide redress for engaging in activities that are illegal under federal law. Let that sink in. You don't have a prayer in federal court if you're applying RICO to cannabis businesses, period.
Right.
Plaintiff's
Right.
reliance on SEVA is unhelpful because in this case, plaintiff's claims were premised upon misappropriation of confidential business information. Krista, ring a bell? Regarding cannabis sales and did not involve the actual production or sale of cannabis. This is a case citing. Here, plaintiff's claims involve the actual production and sale of cannabis, thus increasing the likelihood that any remedy would contravene federal law. Nick, go. You got to own this, buddy.
The court cannot remedy plaintiffs' injuries because doing so would result in an illegal mandate. In short, plaintiffs' injuries to their cannabis business are not redressable under RICO. This shit gives me goosebumps because people don't know this is gold right here.
Well, they're about to, my friend. Keep
I
going.
mean, all right. C. Gonzalez versus Gorsuch, yada yada. The focus, however, is always upon the ability of the court to redress the injury suffered by the plaintiff. If the wrong parties are before the court, or if the court requested relief would worsen the plaintiff's position, or if the court is unable to grant the relief that relates to the harm, the plaintiff lacks standing. Plaintiffs lacks, then they have a whole bunch of court cases. Plaintiffs lack standing to seek relief. Accordingly, the court dismisses the RICO causes of actions. That's
through too. So this is gold, like he just said. But you see the part that they italicized, or if the court is unable to grant the relief that relates to the harm. That's them putting an emphasis on this in their opinion. Okay. Now, what I'm about to describe takes a little bit of kind of looking back the old rabbit hole, and here's where we get into trademark laws. So normally, if somebody has an intellectual property or a trademark value, they've protected that. And if somebody tries to steal that, then you can challenge it in court, which is done all the time. You can't use an Apple symbol in your logo or, an AT&T or whatever. So what happened under the Lanham Act is, I'm going to read Section B. The Lanham Act does not protect illegal activities such as cannabis cultivation in her claims 14 through 15. So remember when we read the first complaint, there were all those numbers for complaints. 14 and 15 are about to get tossed. Here's why. As detailed above, cannabis is illegal under federal law. Marijuana remains a Schedule I controlled substance under federal law. Thus, when a mark is used for cannabis products, the Lanham Act does not recognize the user's trademark, priority, or any derivative claims, regardless of any state claims that may contradict the federal statute. Okay? So, why can't we have these conversations on CCRW, Nick? You know why? We get banned. Anytime we put something like this out there and say, okay, well, if we're looking at the Lanham Act and, I'm MedMens and I've got a logo and somebody's trying to steal my product line, what do? Can we go to federal court? Under the Lanham Act, you may not. Okay, so everything.
How does the federal government have a patent on it?
Well, it's a trademark. So it's a trademark violation. And this is what they're talking about in Iron Angel. So their claims 14 and 15 are dispatched here. Okay. Dave, are you able to read the next one as the Ninth Circuit? Now, the Ninth Circuit's the appellate court. So this is important to catch. Can you read that, Dave, or do you need it?
I can't see it, but
okay.
This is also basic to me.
Let me get through it then. As the Ninth Circuit has stated, okay, the appellate court, extending trademark protection for use on unlawful products would put the government in the anomalous position of extending the benefits of trademark protection to a seller based upon actions of the seller too in violation of that government's own laws.
Conflict.
Bingo.
Right. All the way through. They're acknowledging.
Exactly. As such, because any alleged use of the Iron Triangle trademark was on cannabis products which are illegal under federal law, plaintiffs cannot state a claim for violation of the Lanham Act. Okay.
This is just the federal court telling us that state laws violate
and actually they get to that. They get to that. So go ahead, Nick or Krista. Can you do this one? Because
put it back up on the screen, please.
Coming up.
As discussed above, correct?
Because plaintiffs claim of false advertising.
Okay, we're back to the top. Because plaintiffs' claim of false advertising under the Lanham Act is derivative of the Lanham Act claim, this cause of action fails as well.
Bingo.
Yeah.
You have nothing. There's basically, I'm going to guess, and Dr. Schulman is the son of Francine Schulman, and he's an ER surgeon, doctor. He will be coming in sometime. He's been invited. But this thing is still moving along. It might still have some appeal rights. They're talking about bringing it into state court. God bless them for that. But look at the kind of money it took to get to this decision. Remember, this is like 73. This is ESSF 73. So you had 14, 15, 16 months of high priority, high dollar lawyers arguing a case that ultimately fails because there's positive conflict. Now, who's responsible for positive conflict? The politicians that gave us that in November of 2016.
The lawmakers that wrote the law.
Exactly.
There's a positive conflict from the get-go.
They knew it from the start. And the people that supported this, that made it sure that it passed and then put a cap on any dissension by banning people, are going to be held responsible. Do you mind finish that, Krista?
Bring back up, please. I'm leaning on you for it. Okay. Regardless, plaintiffs must adequately allege statutory standing for a claim of false advertising. See, Lexmark.
You don't have to worry about all that. You don't have to worry about all that. Keep going.
Plaintiffs must show, 1, that they are within the zone of interest protected by the statute, and 2, approximate causation between his injury and the alleged statutory violation.
Which they didn't rise to that. They didn't get that. They get the boot on that. So, as discussed above, go, Nick.
As discussed above, the Lanham Act was created to protect trademarks that involve legal uses only.
Stop.
Where
You got that? Legal uses only.
yeah.
Positive conflict exists. Go.
Where a mark is being used in connection with sales of a specific substance, marijuana, that is illegal under federal law, encompasses a use that is unlawful. In regards to Morgan versus Morgan Brown,
You can skip the citations. Go.
okay, because plaintiff's claim for false advertising rests wholly on defendant's use of its trademark to advertise marijuana products, it encompasses an unlawful use such that plaintiffs are not within the zone of interest protected by the Lanham Act. Plaintiff's claim for false advertising fails.
Do you see how big that is? This is huge because you don't even have that protection in federal court. Because,
Right.
and that could be a CBD product too. All right. That, by the way, that's not addressed here. If it's a non-psychoactive, less than 0.3%, can a trademark infringement be fought under the Lanham Act? I don't know. That hasn't been determined. But one thing's for sure, with Baker Botts, that big high-power law firm, this got the boot.
Well,
Yeah.
they knew that this was going to be the result. They just sucked $500,000 out of whoever it was that was silly enough to get him to represent them.
Listen, I'm not willing to get sued by Baker Botts, but I would say that a firm of that caliber and size should never have brought this case in when that client is exposed to the preemption doctrine, the supremacy clause, where, just as you can see happening, a shitbag like Todd Kaplan files a motion to dismiss and is granted that against Baker Botts. Come on. What's
Unless
wrong
they
with
thought they had a win. I
They
mean,
just-
that's-
It's no different than Henry Wykowski in the Harborside tax issue with Rule 280E.
Yeah, IRS 280. So this is the problem right now, is that there's tons of positions that show positive conflict between federal and state law, which means we, as people that have been harmed by 64, have a class action opportunity. If you have been banned from CCRW, that's a First Amendment violation. If you have been banned because you're a black man running against Jacqueline McGowan, you have a racist discrimination claim, okay? If you are harmed by 64, where they force you to get a license that violates higher federal law, and then take 4.5, 5 years out of your life, pulling money out of your pocket to slow walk a permit that you never seem to get, and then tax you under 280E at about 75% of your gross receivables. There's no way this system works. And there's criminal and civil remedies. So let's find out in C. Whoever can read this, please. C. Nick, you got it?
Anybody?
Go ahead, Nick.
All right. Neither the RICO causes of action nor plaintiff's claims under the Lanham Act could be cured by pleading additional facts because the illegality of marijuana cannot be pleaded around in a way that would confer standing. As such, the court declines to grant leave to amend for these 4 causes of action.
Stop. You see what they've just said? You cannot even amend your complaint based on the reasons it's being dismissed, because at the core foundation, it's illegal at a federal level. And that goes to the top sentence, against RICO charges and against Lanham Act charges.
Supremacy clause.
Precisely.
Higher federal law.
Yep. And it's being applied right here. Go ahead, Nick. Sorry.
All right, D. The remaining causes of action are state law claims, and the court declines to exercise supplemental jurisdiction over them. District courts may decline to exercise jurisdiction over supplemental state law claims based on various factors, including the circumstances of the particular case, the nature of the state law claims, the character of the governing state law, and the relationship between the state and federal claims.
Stop. What did they just say? The relationship between the state and federal claims. So they may decline to exercise jurisdiction over a relationship between the state and federal claims. And their decision there is to dismiss it. So that 16 months worth of high-priced litigation just is kicked to the curb. Keep going, Nick.
That's disgusting. The Ninth Circuit does not require an explanation for a district court's reasons for declining supplemental jurisdiction when the district court acts under 28 U.S.C. San Pedro Hotel Company versus City of Los Angeles.
Okay, but keep going. But
does require a district court to articulate why the circumstances of the case are exceptional, in addition to inquiring whether the balance of the Gibbs values provide compelling reasons for declining jurisdiction in such circumstances.
guys, what we're saying here is this, is that the district court has to articulate, which they've done, why the appellate court doesn't have to look at this. Okay? Why it doesn't get traction in the Ninth Circuit. All right, so that's what they're telling the district court to do, and that's what the district court has done. This inquiry is not particularly burdensome, and you know what? It isn't. It was pretty straight fucking forward what this court had to rule on, and we've been lied to as medical cannabis patients in this state, and it's time we do something about it.
We've also been lied to as voters, you know?
Indeed, across the board. So, because the remaining 21 causes of action arise under California law, the court finds that this case should be dismissed entirely, as the state law causes of action substantially predominate over this matter. Now, what's my problem with this? They're basically saying that the state has substantially predominated over an aiding and abetting of an illegal federal law. All right? Here's two problems I have. One, cannabis is legal under international law for medical and scientific purposes, okay? So the federal courts are trumped by the international courts when it comes to that. We have the United Nations Single Convention on Narcotics, where it states clearly that all member nations must allow cannabis for medical and research purposes. But in this particular paragraph, not only do they ignore that, they also give a tip of the hat to the states and say, take this out of federal court, bring it back to state court because you substantially predominate this, okay? But what were we sold? We were sold 64 where there would be no positive conflict. In other words, you could just as easily be arrested by the federal government for violating the Controlled Substance Act as you could be with getting kicked out of federal court because you don't have standing. You are not protected by the state's license, and the state will not protect you either.
Right.
So the court has dismissed, moreover, the court has dismissed all federal causes of action as discussed above, and accordingly declines to consider the merits of the remaining causes of action which involve a business and contract dispute, the jurisdiction of which is more properly left with the state court. Conclusion. Nick, you got it.
Sure. For the reasons stated above, the court grants MIH defendants motion to dismiss with prejudice. Defendant Howden's motion to dismiss is denied as moot. It is so.
Two things that just added there. They're saying with prejudice, so that means you can't amend it. You can't come back for another, swing at the pitch. And then as denied as moot means it has no merit whatsoever. It can't even be argued. So you guys have seen where we're at with this right now, and this is where a number of great friends of the farm 151B and what we're doing have come together and said, what do we do about it? So that's where we look to guys like Nick to get elected, repeal 64, and bring in the Restoration Act, which brings us back to medical cannabis, not taxed, not profit. It's fee-based, and it has been worked very hard on by a lot of people so that it will make sense to bridge what happens when the 64 is taken out. We have to put something in its place, and Restoration Act worked hard to try to do that, so it wouldn't screw over all those people that have gotten these licenses. But the people that have been harmed, that have spent money and have not gotten these licenses because they felt it was the right thing to do, that they were getting right with the law. No, now they come together under a class action, and we're interviewing attorneys right now to find out who is best suited to pick up this class. Not everybody should be figuring they want to be part of the class. There are people like Iron Angel and Miss Schulman and her sons that have a bigger claim. So when you take a class action, it's split. But if you have an individual case, like Krista's case, for example, that's gone on. Krista, tell us, how many years have you been in the application process?
We were asked to register in 2016. We had to wait a year for the ordinance to be completed. It took about another year to get our applications prepared according to the ordinance. We turned those in 2018. So 5 years if you want to consider from the beginning.
And how have you been able to make money in the cannabis industry since then? You haven't been able to do any license grows, right?
No, we make less money. We can't have renters on our property as per the sheriff. We can't pull permits to anywhere on the 55 acres for any other purpose. So we can't do any other sort of business while we're waiting for that to happen. So our choice is to keep our approved cannabis license or give it up for another permit for something.
And people are killing themselves. There's suicides. They just feel like all their dreams are taken away. And we're seeing a lot of pay-to-play corruption. The FBI is investigating this, and names are coming up that we all seem to recognize. So knowing what you know now, Krista, would you, especially after reading this case, what do you believe is your responsibility today? Should you continue to pursue that license knowing that there's a violation of higher federal law with positive conflict? Hard question to ask, but you're invested in this heavily.
We don't have any choice. If you give up the license, you give up your right to get any type of restitution. I just had an epiphany when we were reading it about how, the state put the local government in control, and then nobody's in control of the local government, and then nobody's in control of the state, and then we're not under federal law, so we don't have anybody to oversee what's happening.
So here's what I'm
protection.
Here's what I'm proposing. All right, your local governments in many cases are corrupt. They're selling the licenses, they're slow walking others' permits, they're driving you broke, while other people like Helios, for example, seems to continue operations, break all your environmental laws, steal water, yada, 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 and they continue to profit. But the taxation and regulation is overbearing, even to people like them. So they have to have a back door where they're selling their weed, on the black market, if you will.
Well, and it's finally being discussed. And I've been asking this question for 5 years, since applying for a license. What is the actual price of a marijuana product that was grown legally?
Right.
There's overhead, there's licensing, there's all the other overhead costs that cost us to produce a pound. So I'm pretty tired of all of our pound prices being set, or our wholesale prices being set by black market. They don't pay their trimmers, they don't pay the fees, they don't pay rent, they don't pay taxes, they don't pay licensing fees, they don't pay the water board fees, they don't pay bond fees, they don't pay for insurance, et cetera, et cetera, et cetera.
So let me ask you, if you have criminal activities going on and you have agencies like the FBI and who else that was involved, IRS, is going after those corrupt pay-to-play politicians, you have criminal acts. But on the district attorneys for these areas, if they were willing to come on board as a co-plaintiff in a class action and say they too were lied to when they adopted 64, okay? So they were given a law that forced them to violate higher federal law. All of a sudden, not the ones that were stealing from us, but the attorneys, the district attorneys could, on behalf of that county, become a co-plaintiff and seek recovery for everybody that in their permitting process has lost money. And that's a big fund. It goes to the local government, the local district attorney, who would then distribute that to those people that had been licensee applications, okay? This is why it's so important to, know your friend, keep him close, keep your enemy closer. We really have a problem in this state. And a lot of it comes down to local governments who saw this Prop 64 as a way to recover from just crazy financial decisions that they've made over a year. Like they have unfunded pensions, for example. They were looking at ways to recover all this while buying speedboats and helicopters and everything else. This forces us all to relook at this and say, because of Iron Angel and the way the federal government looks at cannabis-related activities, we have no protection at the federal level. So we're basically cast adrift. We got to do something about it. And my proposal is that a class action come together that forces the state to realize that, yes, the federal government says there's positive conflict, and next, what are you going to do about it?
So, unfortunately, Daryl, if you have a clean county, that's okay. That would be one thing. But, our attorney we have up here, he's just the most naive and nice guy for an attorney. He thinks everything's hunky-dory. And he sent me in an email. He actually said, you'd be stupid to think that this starts and ends at Adam Hill and does not go up to our superior courts. Right. So when you start mentioning superior courts and you start mentioning the district attorney, that's under the assumption that they're not part of the shenanigans.
I would say this, because I know that to be the case. I see it in my case, which was state court and now federal, and it's huge. It's just you pull on the string and the whole ball starts coming apart, right? Krista, I believe in my heart of hearts that we can take the district attorneys who are officers of the court and get them to agree that Prop 64 is the worst fucking thing that ever happened to local government. We cannot take and get a completely clean slate across the state. But I think we can take the district attorneys, because either they're going to be a plaintiff or a defendant. And in this matter, if they're a plaintiff, we're going to exact revenge quicker on a class action than if we try to go after all your district attorneys who, in my heart of hearts, I won't even say this, but I know how I really feel about it. I believe we need the district attorneys to come back and say 64 was a lie and the federal government proved it in the Iron Angel case.
Obama refuses to do that despite him being informed that with the letters that was sent to him. And I mean, we can outline this case to him and send it to him, and I'm still sure we won't get a response. And that's how deep the corruption goes in California, is that we have elected officials refusing to recognize that we have laws that are contradictory in the state that are causing more victims, to legal businesses.
Well, there's a principle called res judicata. That means it's been decided by another court. So in res judicata, this federal court has already decided positive conflict exists. There are attorneys, they'll remain nameless, who are heavily invested into what positive conflict exists between state and federal law. But now we've already decided that. It's there,
right,
apparent. So now that same type of energy has to go to the federal or the state court levels and argue the damages that have occurred from. And I would look at it this way. If I'm an unlicensed grower, I'm an American. I am not going to violate higher federal law for growing medical cannabis. I think about Eddie Lepp and Sandra Castaneda and all the stories I've held, who, by the way, have helped build the Restoration Act. And these activists, that we stand on the shoulders of, like Dennis Perone and others, over the years to get medical cannabis in, and then you hit a switch and it's gone. And you have an absolute lie in 64 that said no positive conflict exists. Folks, I'm sorry, but this isn't going away. This video is going to be archived. We're going to be looking for you if you've been harmed under 64. And that includes illegal raids. That includes people that have been raided and had no cannabis. That includes all the flyovers. That includes the permitting processes that have never been completed. They keep putting the bar away. That includes public officials who want to come clean. That includes deputies, sheriffs, who are tired of being bagmen to let the illegal dispensaries live while the specially protected ones, or the ones that aren't protected, get shut down. 64 hasn't changed any of that. There's still all this white market cannabis flooding the black market because they don't have enough resources to sell it. And that's the problem. It's been a lie, and we got to fix it.
Cartel wears ties.
Sort of reminiscent of tobacco or any other plant like that. I mean, they managed to do this to us with tobacco. I mean, you can't legally grow tobacco in this state. Smoke your own cigarettes. You have to go buy a packaged cigarette because that's supposed to be safe for you. But we know what they put in packaged commercial cigarettes. It's bad. It's all bad.
Right.
So we'll soon be looking for co-plaintiffs that can get us a declaration as to how they suffered. There will be no charge. The attorneys will look at it, and then if we're looking at 40 plus, my guess is we've got hundreds, if not thousands, that have been affected by the passage of Prop 64. This becomes a really meaty class action. And by the time you start looking at the local governments who are also going to sign on and saying, yeah, none of this would have happened. You could even make the argument that pay to play couldn't have happened, right? That this table money wouldn't have happened had it not passed for 64. That's not much of a defense. But again, I'm not a lawyer, so I don't know if that'll fly. At the end of the day, we want recovery because we've had 5+ years of this and it's over.
So, Cotton, I want to encapsulate this in plain language for the people out there who may still be confused as to what the hell we're talking about, and you just correct me as I go, okay?
Sure.
So basically, it's like this. If you're in California under Prop 64, if you want to legally start a cannabis business, even if you get raided by local authorities or federal authorities, if you go to sue, you can never get paid back for any of what you lost.
You're right in a lot of respects there, but what scares me is that last paragraph in that appeal decision where they're saying this is more of a state court matter. It's not saying that the state is violating higher federal law. We're going to make that crystal clear in a state court action that they are, and that's been proven by the fact that we've been bounced from federal court, or at least Iron Angel has. Now, look at it from the other perspective. Why will the federal government go in and bust an illegal grow and use state resources to do that? They'll combine together and do that. Nevada just did it at a big convention. I forget what was the convention. And here's what we're seeing. They're saying, okay, while it's a controlled substance, if you're licensed in the state, we'll help you shut down unlicensed activity. So the DOJ has a problem there. They're helping build a monopoly from people that are also violating the Controlled Substance Act, okay? Iron Angel complaint proves that. So what's the next step, possibly? When big government, big monopoly, I mean, there are governments right now growing their own cannabis. They've got 1 million plus square foot under canopy, that is, for cannabis in the local government's name. So your legacy growers, you don't have a prayer. You're done. The local governments are going to take this, and then they'll overproduce and they'll kill our resources. There's not enough water and everything else. The only thing that undoes this is to prove out there under the light of day that 64 was a lie. And that's the reason we're here, guys.
Our little friend Claire made a wonderful point when she spoke during one of our last public comment hearings, is that she pointed out to the Board of Supervisors that the whole point of giving us the opportunity to get our foot in the door as legacy growers or small farmers was to give us the chance to get on our feet and establish a brand before the large companies came in and large licenses. And she flat out told them, you guys took that away from us.
Yep. And it's sad. And my heart goes out to everybody that's in the application process. And especially when there's multiple applications for a single location and they've already sold that project out. They know who's going to get it. What they're doing is taking non-refundable money, and you'd have no prayer of ever getting it back.
They slow roll the mom and pop growers until they bleed them dry. And if it's not blatantly obvious that the greedy government of California, state and local, are profiteering through the over-exorbitant taxation of this plant and enriching themselves from a controlled substance, I mean, it's right there in front of us. It's obvious as can be. And both sides are laughing at us, federal and state. I'm just appalled by the entire situation because it's so simple. It expressly says in the Controlled Substance Act that you cannot sell cannabis and you cannot profit from it. And 64 mandates both, that you have to sell it and you're selling it for a profit. And the state sits on the sideline and collects this money. Right. And if it wasn't federally illegal, the state would be growing the weed themselves and keeping all the profits.
So have we all missed the fact that it's okay for Helios to underreport $9 million in income on a non-profit business, and he can pay $3.5 million in taxes for restitution? That hurts my head so bad.
Yeah.
The Department of Justice is saying that he underreported by $9 million. Reported by what? It's a nonprofit.
Dave had the same issues when he was before the State Board of Equalization. He pointed out, what was the thing we brought up earlier? They asked how many collectives pay taxes in the state, and they said all of them.
Well, we had Bill Panzer, Dave Hodges had Bill Panzer write a letter to the SBOE saying, according to 215 and SB 420, the only legal entities are collectives or cooperatives, and they're supposed to be non-taxable. Otherwise, it would be violating federal law. And that's when the SBOE came back and said 0. And we're like, wait a minute, there's thousands of dispensaries and thousands of growers, and not one of them is legal? They don't have the legal entity to even be in the business. And the whole scheme, and this is why they wrote 64, is that the state, on the SBOE level, the Secretary of State, and as far as the district attorney, Kamala Harris, and the whole shebang, the thing is a setup, is that they misled and misguided everyone into forming everything and anything but a collective and a cooperative, because it is legal to tax an illegal entity. Yes. So if they push everybody over here to where they're not a lawful entity, then yeah, we can charge you sales tax. So we figured out, wait a minute, why aren't they telling us the exact opposite, that you need to be a collective or a cooperative and that we're tax exempt? Well, because then California couldn't make any money at all. So they figured out the scheme how to make some sales tax by pushing everybody over here, misleading us into an illegal entity. And then when Dave Hodges and I got wind of it and started taking action against them, they went, "Oh shit! People are going to find out we're violating our own state law, so we
guys,
can enrich ourselves." So,
Dave, you're a plaintiff in this case, Dave. What's happened to you is the foundation of why 64 was created.
yeah, I mean, my lawyers told him you can't call it sales tax; you should call it an excise tax or something else. And guess what? There's a new excise tax on top of the sales tax, and this and this and that. And
yeah.
So they're just profiteering. They're profiteering even more under 64.
Right.
The ma and pas are getting slow rolled and bled to death, so that they are out of existence. Medical has been abolished,
and corporate is taken over.
The whole thing just saddens the shit out of me, folks. And
no
other industry. If alcohol, if you went to buy a can of beer, and they charged you 25 to 45% on the dollar for that beer, the majority of America drinks alcohol, some 60 some odd percent, would be in an uproar. It'd be like, oh my God, they're ripping us off for our alcohol. Well, because just barely 20% of the Americans consume cannabis, it's okay to bend us over and screw us up the ass for 25 to 45% on the dollar, because the local and state government are getting rich, the corrupt corporations are getting rich. And meanwhile,
American Revolution happened.
I just want to ask one question because we're running out of time. And
I'm sorry.
And that is this. If you have a crystal ball looking forward and you are a lawyer and you have to argue in state court that there is no positive conflict, as was passed on Section 11 of OMA, and you have to consider the language that you just read tonight,
you won't get anywhere, because the state court system is so corrupt. The judges, the lawyers, all the way down, up and down the pole. I mean, when I took my case against San Jose to the appellate court, they said, "Oh, well, Mr. Armstrong can take the fifth."
That won't happen.
Because that would violate his Fifth Amendment rights.
Here's the thing: we have a class. And you have to undo an illegal law. It's a void contract with the voters. It has no bearing. It has no standing. That's why Nick Wildstar can repeal it his first day in office. And if he has the judiciary behind him, but he has the executive authority to do that. Okay.
Well, let's send out notice to any person that's bought cannabis since 1996 when 215 passed, and anybody that paid taxes, sales taxes on that medical marijuana, has standing to sue the shit out of the state of California and the local governments.
And it's not like they don't have the money. You know, all that money that comes in from cannabis licensing and taxes and everything goes into special trust funds. They're up to $11 billion of undisclosed beneficiaries. This is slush money for the Kamala Harrises and the Gavin Newsoms of the world, okay? That money misses our general fund. It's not audited, and we're going to follow the money. When Nick gets in office, we're going to be doing audits of where all the money's going and why we're not metering things like our water. You know, we're running out of water in this state. So we need audits of these issues. Cannabis is number one. It's like the one thing we can point to that we know for sure lied, positive conflict exists. That is the purpose for tonight's podcast.
Exactly. Well, thank you very much for clarifying and putting all of that in words that can be understood, hopefully by the majority of Californians, enough to take action, whether you consume cannabis or not, whether you like cannabis or not. You know, if anything, you should be supportive of freedom and liberty and the law. As much as people want to say just follow the law, here you are. You know, it's people following the law and still being treated like criminals, still having their livelihoods destroyed because they're simply being law-abiding citizens.
Guys, there's so much more coming too. We got to hopefully get Nick in office, but if he's one of those people that has to do it in 2022, we're going to be there for you, Nick. But the bottom line is very public. California City and County Regulation Watch. You're going to be seeing some new things hitting in about a week that are going to continue to expand upon this. We're just getting started. Join us over on Very Public and understand that we need those people that have been harmed to come forward and be part of the correction, the restoration what are the rights that were taken from us.
Yeah, because Dave put it in an idea to where people can think of is, hey, you can go at it alone and sue, but the state is still going to screw you at the end of the day.
They won't do that with a class.
Band together, right? If we band together, file a class action lawsuit, that's going to blow the lid off of it. That's what we want to do.
You'll get the media attention. You'll have every newspaper. You'll have national. What you're doing is actually got national implications too, because the MORE Act is 64 10x worse. So
right.
Please,
what they've done is a reverse Robin Hood scenario on how the rich steal from the poor.
Yeah.
And
exactly.
And the poor line up to go get ripped off at 25 to 45% on the dollar and clap and say, oh, what, marijuana is legal now. Well, oh my God.
Or even paying for it. You know what I'm saying? Through the licenses, like with Krista's case, paying to get screwed in the end by the same government that is supposed to protect you. So
then they sit and wonder why the black market's booming. Well, oh my God, it's $20. It's $20 for a gram of weed because there's 20 hands in the cannabis cookie jar. Everybody's getting a cut.
And they're taking away your traditional 6 medical plants. I'm sorry, I deal with a lot of ladies that are over 55 and 60, and they're not going to be bending over in a tent in a closet growing in light. And in our county, you cannot grow out of doors, period, end of story. So it's pretty bullshit that these ladies pay a lot of money to own 3 to 5 acres, and they can't have 6 goddamn cannabis plants in their back fucking yard.
Right.
I just want to tell everybody here, I love your passion. I love your years of activism. I love your idealism. And we wouldn't be even having this conversation if it wasn't for people like you. You are appreciated more than words can describe.
I want to say one more thing before we sign off here, because you pointed out about the national implications of this. More than half of our nation has cannabis laws in each state, whether it's recreational marijuana or medicinal marijuana or whatever the case may be, and you have businesses being created under those laws. Yes. If they ever go to federal court, because I just released an article about this on my social media about how cannabis businesses are starting to file RICO lawsuits, they're going to be spending an exorbitant amount of money and have all of those cases be kicked back and be dismissed. That's money wasted down the drain. And it isn't until we start changing our state laws and having it take superiority over federal drug law to where we're going to be able to overturn this in a way to where it actually protects those people that are supposed to be protected under these laws.
Not forced to violate higher federal law. The real Americans are the ones that are not getting licensed. Maybe they don't have the money, they don't have the connections, for whatever reason. They think they can stay off the radar. But guys, I got news for you. There's only one thing that matters, that you don't go to jail. All right. And if they have the right to put you in jail for violating federal law, guess what? We can talk about a dozen people right now. Charles, right? Dave? I mean, all the people that are going to be doing federal time for the Controlled Substance Act violations. All right. So don't tell me your state's making it legal. If you're taxing it, you're violating our international charter under the Single Convention on Narcotics by creating a recreational for-profit entity, which is in direct violation of our international obligations. We'll remind the federal courts of that too.
Yes, indeed. Well, thank you all again for bringing this information to light. I'll continue to pound the pavement and get the word out there. The election day is fast approaching, September 14th. I mean, we can truly have a revolution here, but it's up to us to get involved, get mobilized, and take action right now. Because if we wait till next year, more people are going to be harmed because of it. Or if anything, they may try to switch up the laws again before then to create another loophole for themselves. So if anything, the best way to protect ourselves is strike while the iron is hot. This special election, this recall, is a great way to do it. Since it's a win by plurality, I can easily win with 10, 13, 20%, which is unheard of course, in the general election. You got to win by majority. So this is an opportunity for everybody in the cannabis community and Americans, like he said, this boils down to us fighting for our freedom. You know. Hello there.
Hey, get that guitar up. I want to hear a song.
Oh yeah,
What's that?
they wanted to, they made a request, babe. I want to hear a song.
Which song?
Roll another one.
Yes, but
I need a
thank you
cigarette
again,
to
guys,
kill
for
my
the
whiskey
conversation.
breath. And a big joint to get me high. I need a snort of cocaine to numb the pain. A shot of heroin to just get by. Although wine is fine, I got a beer right here to chase away my yesterdays. And crystal meth is my best bet when I really want to fade away.
Nice. All right.
All right, all right.
You
I'm
guys
gonna have
gotta
to do a song with my man.
exactly right. A little country mix.
Right?
Yeah, right. Cowpunk forever.
Guys, thank you very much. I got to roll. I'm running out of gas. But please join us on Very Public Facebook and look for more things coming. This is just getting started.
Yes, indeed. Thank you all, and take care. Long
Good
live
night,
liberty.
Everybody. Night.
Peace.